Objection, Your Honor. Why do attorneys sometimes get to interrupt the other side with what's called an objection, and what does that even mean? A lawyer may object when the other side is attempting to introduce evidence that the lawyer believes is outside of the rules of evidence. As an example, hearsay. Objection, hearsay. By the way, hearsay is an out-of-court statement made to prove the truth of the matter asserted. And by the way, there are 23 exceptions to the hearsay rule. So if a party objects to hearsay, you'll usually hear overruled because there's 23 exceptions. Now, the decision to actually object is one of strategy. A lot of lawyers don't understand this. You don't object every single time that you have the opportunity to. Sometimes when you object, it can actually backfire, and it can make the jury think that you're trying to hide certain kind of evidence, so you don't want them to hear stuff. So it's very important for an experienced personal injury lawyer to closely consider what they should actually object about. Sometimes very sneaky attorneys will actually sneak in what's called a speaking objection. It's when the objection isn't that good, but they get to sort of tell the jury why that is. Objection, Your Honor, that isn't even what they said. Something like that. There is no such thing as that isn't what they said objection. That's called a speaking objection. It's impermissible, but you can get away with it maybe a few times per trial. So for strategy, you save that one in your pocket and use speaking objections. Now, responding to objections. Sometimes the other side will have a really good objection that prevents you from getting in the evidence that you so badly want in. Well, there's two ways to handle that. One is you can sit there and act like you just got run over, or you can be like this and ask your next question as if that didn't do anything to you. Believe me, when you do the second, it makes that objection almost not even matter anymore. So as you can see, the process of objecting and even responding to objections can be a quite complicated and strategic move in a trial. It's something that takes years of experience to understand and to properly handle. If you have a personal injury case, it's important to hire a lawyer that will actually go to trial. And if they do go to trial, it's very important to hire someone that understands how to actually do a trial, understands the strategy, and has a track record, most importantly, of winning.